Peace to the family. Welcome, welcome, welcome. Today we're going to do an important show on reparations. I haven't streamed on this channel directly for a while, so I'm going to give the people a chance to get into the building. Uh, One of the important things is I think that we are actually being misdirected in our conversations and our objective by social media. And um, when I mean social media, I mean there are groups on social media that seem to be, in one sense, doing the right thing on reparations, but I find that they are misinformed. And so I spent the last 2 weeks on other people's channels, uh, just trying to get a feel for where they are on reparations and what they know about African history. And what I found is just uh, horrible. Hey, Christoph Heretic, thank you so much for being the first one to join. And so we are having this conversation on reparations, and we're going to try to have an adult conversation on this subject. I find that social media groups largely are misinformed. I also find that some groups have been renaming history, history of what is in print, what our ancestors used, right? Here, African American history, Black Americans. And sometimes we had to call ourselves Negroes. Barn Dog, my brother. Hey man, now I feel good. Barn Dog is here. I feel real good. Um, I find that these groups are coming back and doing revisionist history on the Black American experience, so much so that they have to rename it. But the two things like the foundational Black Americans or the American descendants of slavery. And what I find is that doing that kind of tarnishes the great history of our people who called themselves Afro American, like El Hajj Malik El Shabazz, the person that we know as Malcolm X, and uh, Dr. John Henry Clark, right, who called us Afro Americans. I find that people are uh, I'm going to say misinformed about the term African American. So we find this term in the 1780s, right, being used and in print. And now they want to say, well, Jesse Jackson started African American, but he did not. So I find that some of these groups and some of these people are, in fact, reinterpreting history, uh, not knowledgeable of Black American history, haven't taken any formal classes in Black history, or African American history. And I also find, hello, Mika, how are you? And I also find, thanks for joining, Mika. And I also find that, of course, that they are reinterpreting parts of Black history for themselves. I also find that in my conversations, because I spent the last 2 weeks trying to figure out what are the terms that they're using and why they're using it. And I hear a lot of terms like social boosting the truth, or social boosting an agenda, right? A lot of people never looked up the word social boosting to see actually what it is. They just take it for what it is. Um, there's lots of problems on reparations. So I'll wait for a few more people to get into the channel before I begin. I have a presentation, and then I want to have I want to talk about it, and then I want to invite you to come in. So why do we need to reinterpret the word Black American? Why do we have to do that when the people fought for our liberation and fought for our freedom? Uh, the freedoms that we do have, they use that term. Why do we have to reinterpret it? Uh, what are the aims of these new groups? Uh, to do what? Are they directly involved in reparations movement? Question mark. Are they directly involved in the freedom movement? Question mark. Are they directly involved in organizations that have been started who have done the work? Question mark. Right? I don't think so. I think that many of these people are just social media people talking, and you have freedom of speech, and but you should use your freedom of speech wisely. Brother La, my brother, peace to you. You should use freedom of speech appropriately, right? You should be well read on the subject, right? You should not misinform people with the limited amount of knowledge that you come out and you show. There's some other problems. The A big problem is um, that at least one of these groups began our uh, presence in the Americas in 1526. 1526, if that is the beginning, well, that was under the Spanish. That has nothing to do with the United States. We cannot be talking about reparations in 1526. And these Africans were cultivated during the enslavement by the Spanish, and they end up speaking Spanish. We speak English, right? Then there's the Louisiana Purchase. There's the French involvement in the territories, and ultimately it was signed over to the United States. Those Africans who were in the Spanish territories uh, never met the African American that will come or the Black American that will come later. That's just history. The Africans in the French period, right? We know them largely in Louisiana and those territories. Excuse me. Uh, they, in fact, did meet the African Americans. Those survivors did actually meet the those survivors under the American slavery. Uh, so, but when we think of reparations, we think of reparations traditionally from the period of the United States or the colonies uh, from the British. Oh, and there was, of course, there's the other period where the British uh, involved themselves in slavery. Okay, we're not suing the French, we're not suing the Spanish, we're not suing the British. I mean, the British, the French, and the Spanish. We're not suing any of those. We are looking at the period of 1776 onwards in the United States. Now, there's also been a lot of infighting. Okay, so Afro Caribbeans seem to be the scapegoats. Scapegoats of what? Some comments that they're making. Everybody has freedom of speech. Those pro and those con. We all have freedom of speech. But those are people talking, right? I think that they miss the forest with the trees. The issue is, who should we be directing our energy to is the oppressor, not people that look like us. Then there's this argument that we have to delineate ourselves um, from other groups. Well, I think that we're already delineated in some aspects as far as culture, longevity in the United States, involvement in uh, abolitionist movements, freedom movements, uh, um, civil rights. I think that we're already delineated. I don't think that the groups in the Caribbean who are coming here or the African migrants are a threat to us. Unless you read history like the newspapers and your sports games, where you certainly want to separate out people because there have been great events of heroism from the Africans that came in after slavery in another period. And so our reparations movement should talk about not only enslavement, but there's a problem with enslavement, and we're going to get to it after I show my video, to the Jim Crow period or the Reconstruction in the Jim Crow period, right? Where there are other blacks from other places in America. The groups ADOS and the groups um, uh, Foundation of Black Americans feel that they should not get reparations. Well, let me tell you the truth. Um, in order to get reparations, you need congressional vote. Then you need the Senate vote, right? Then you need the president to sign. So you need all those things in federal court if you're talking about that form of reparations. There are no reparations cases except for the Malcolm X family reparation case and the upcoming Tulsa massacre case. There are no more reparation cases in federal court for good reason, right? So using reparations to carry a load is really problematic because where reparations is actually happening is in cities, states, and counties. Cities, counties, and states. Those are what we call local reparations. And to be entitled to any of those reparations, you have to be a member of that city, county, or state, right? Those reparations movement are going on very nicely without social media help. Social media has not helped those local reparations. Uh, where those local reparations were formed were from county officials, from community people, and a lot of these people are in a generation that was born uh, in the 60s and the 50s, those groups of people, 50s, 60s, 70s, those groups of people. And those type of people or hardworking people, they don't rely on social media for the news. They are old school. They do books, they write, they come to meetings physically, and they vote. This generation that we have, really in the 90s and 2000s, uh, they have problems with voting, so they don't go to the polls. They don't write. They don't research really well, right? They use Google for most of their research, whatever they can Google. They're not part of those local reparations movements. They're not. So what we have now is people trying to carry a load of reparations because that's where these groups, ADOS and FBA, formed, right, to delineate themselves for possible reparations from the oppressor. Problem with that is that, of course, they're not the thinkers, they're not the long term planners. Reparations for one generation is really problematic. So, without further ado, I am going to share my 4-minute presentation, and then we're going to talk about some things based on uh, what the chat, what I think that the community needs to know, and what the chat says. So let's see if I can share. This is the new platform, and so I haven't used it often. So let's see if I can share screen. Great. Here is the screen, and I'm going to share the system audio. Great. So it's only 4 minutes. So by the time that you get your popcorn, it'll be over. Um, Here is something that I want to say right off the bat, right? A spoiler alert. Do you know in the last reparations case, the Deirdre Farmer Pellman case, that in that court, uh, in that opinion written by Posner, right? Do you know that, or what we have found is that we cannot get reparations? Watch this. We cannot get reparations for our ancestors. Let me say that again. The last reparations case, called the Deirdre Farmer Pellman case, outlined that it is almost impossible and very difficult for plaintiffs in a federal case on reparations to represent their ancestors. Did y'all know that? Ben Nosut, peace to you. Thank you. Did you know, family, that we cannot represent our grandparents, great grandparents, great great grandparents? Did y'all know that? Did you know about that burden? So, if that is true, and it is very true, then what are these people talking about when they're talking about reparations? I know what's going on, right? They're building their social media. That's all they're doing, building their social media. Because we cannot have a suit on behalf of ourselves for our ancestors. You're going to find that out when I read the Farmer Pellman case. You're gonna find that out. And then when you find that out, you're going to have to look at some of these people that's talking about reparations side-eyed because they have been Thank you, Mika. Yes, I'm going to start building up this channel. And if you, for those people who have come, thank you. Please press subscribe, but I'm pretty sure you have because you know about it, and please share it, right? So these groups of people are using the term reparations to get you emotionally, and they have not read the Deirdre Farmer Pellman case, which we're going to read tonight, right? So you're going to have to look at these people side-eye because they're trying to get you. The only reparations that we can count on is city, county, and state. Mostly city and county, where our peoples really are in cities and counties. And those, unfortunately, only affect those people who have residencies in those cities and counties. Okay, so now you know. Now what I have to do is actually have to show you, right? So you can look at these people side-eye when they say, we're doing this for reparations. And what about we represent the represent? No, you don't. No, you don't. Again, the reparations movements that did not need social boosting. They just needed hard work. If you want a social boost the work that's going on. Don't try to take over it, right? And this thing can't be about hip hop, the origins of hip hop. Why are we talking about hip hop when it comes to delineating our people? Hip hop is a cultural movement that has grown way past hip hop, past rap, into other musical forms. Why are we focusing on little comments about who started hip hop? Well, if you wanted to do something for hip hop, which you really do not, then those people that you talk about, Charlie Rock, right? Disco King Mario, right? Kool Herc, Bambaataa, you don't support them. You don't give them a dime. You will give content providers money, but you won't give the origins, the pioneers of hip hop. Why are we having arguments about who started hip hop? Right? Whose is it? Is it Black American or foundational Black American? Is it us? Well, the problem is it started in the Bronx, where I live, right? In a neighborhood, in neighborhoods that are close to me, like Bronxdale, when I was living in Castle Hill Projects and went to Stevenson High School, those groups of people came to my high school. My high school, Stevenson High School, is also where uh, uh, a center point of a lot of parties. Uh, but most of the parties took place outside, right, in parks in the projects, in Monroe Projects, Bronxdale Projects, uh, Sackworm Projects, definitely Sedgwick Avenue projects, right? I think I said Monroe, Soundview, Bronx River, right? It took place uh, around the nine, right? Those areas, those groups, the nine crew, the Casanova crew, all of those, it took place in the Bronx. And there were people from Manhattan that came to the Bronx and other places, right, that took part of that. It's a Bronx thing, right? It's not the whole African American experience. Stop that, right? And many of you people haven't been to the Bronx. Stop that. Just leave that out, right? So when I tell the truth, Barn Dog, people are gonna get mad. Why are you talking about hip hop, right? When and saying who was there and who wasn't there, and you don't know the history of the Bronx. You don't know the Bronx people. You don't know why the environment that predated hip hop. You don't know about the truce, the murder, the truth, the killing, the truce. You don't know about the segregated gangs, right? You don't know anything. You hear about the Black Spades, and you hear about the Savage Nomads, and you hear about the Silver Skulls, and you hear about, but you don't know about it. But what you should know is there was a truce, and once that truce happened, then the rebuilding of the Bronx began. People can move to other projects. The Bronx could be less segregated than it was, right? People can move freely. You can learn about other projects. You could visit. Prior to that, you could not. Well, why are we talking about that? Why is it important to, when you're talking about things like reparations and delineating yourself, focus on something that you don't really know about, and you don't know about Black history? So, yeah, Wu-Tang is for the children. Wu-Tang. Wu-Tang, shout out to Staten Island, shout out to Wu-Tang, and shout out to all of the communities. Okay, so let's start here. I'm going to start here. So I hope you can all hear and listen. Okay, let's go.
There has been renewed talk on reparations through social media.
Sorry, I got to start it over. Let me minimize this. Great. And let's start it. Okay, here we go.
There has been renewed talk on reparations through social media, i.e., foundational Black Americans. What we have found is that these groups are arguing with Blacks from the Caribbean and Africans, instead of doing the work of reparations, which requires hard work and planning. Unfortunately, what these young people do not understand is that we do not have rights to our ancestors' estates, so the court will dismiss our cases on our ancestors. Though the states, through Black codes, have prevented our people from forming trust and estates and organizations through Black codes, the courts will argue successfully we do not have rights to what happened to our ancestors. They don't know this. Further, we should be similarly situated as the Native Americans. The Native Americans have a following from the Marshall Treaty and subsequent cases, ancestral rights and legal status, trust land. Much of the remaining Native American land is held in trust by the federal government, with the beneficial interest remaining with the tribe or individual for. Sovereignty. Tribes are recognized as sovereign entities, but this sovereignty can only be diminished by Congress for land claim settlements. Some tribes have pursued land claim settlements through the U.S. Congress to reclaim or receive compensation for lost lands. 6. Land back movement. There is a growing movement among indigenous peoples demanding the return of ancestral lands and national sovereignty for each tribal nation. 1. Instead of arguing about who started hip-hop, we should be constructing case arguments on having rights to our ancestors' property and crimes against them. This is how I know that social media missed the big picture. These foundational black groups, as they are called, seem to be talking to their social media audience and not talking to the people actually working on the ongoing reparations movements in the United States. They believe they are doing the work by signal boasting reparations. They cannot be talking to litigants who are in court or going to court because there are no reparations cases pending except the Tulsa reparations case and the Malcolm X family court. I haven't heard any FB report, though ADOS have. The Tulsa case deserves unity from all Black Americans, but we are in the infighting or ignorance of what is really going on stage. They cannot be talking to lawmakers because Congress has not reintroduced a reparations bill. They cannot be talking to presidential candidates, certainly not Donald J. Trump. There are reparations movements in the cities and counties and some states. In this case, these people need your support, not any leadership from you. In these circumstances, unless you are a resident of the city, county, or state, you won't receive their versions of reparations. The FBA has identified individuals who talk against Black Americans, but has not found an organization or lobby group of Black immigrants talking against reparations. People have freedom of speech as they do, and those seemingly talking against reparations are just people, not groups. Shake my head. The foundational Black Americans are talking, but they are not talking to the people involved, but to space. The best they can do for signal boosting is to identify where reparations is going on and simply report. What we can do is find, support, and report on cases like the Tulsa case and the Malcolm X case, and these cases do not require infighting between ethnic groups. What is hilarious is that New York City, with a large Caribbean population, just voted into law a reparations study. What is the answer to this on tethers? These brave African Caribbeans in the city council did the right thing. In my opinion, people need to know what we are up against, and it will take a reparations fund of several $1 million to do a suit well in federal court and almost impossible hurdles. So there is more to do than just talk about it. We need to know the mechanics, where we stand now, and what are the options.
Okay, great. Okay, so yeah, I have an echo. I figured out what the echo is. All righty. So what I think I should do is I should step through the video again and play it back and then stop and comment on it and then go on and read to you the last reparations case to show how detrimental it is to federal reparations. Okay, so let's just do that. Okay, let's just do that. Okay, so I am going to mute my mic, and then when I want to speak, yeah, it's going to be complicated. When I want to speak, I will make some points. Let's see. Well, I could just sum it up. Let me just do this. Let me just stop sharing my screen for a second and just sum it up. Okay, so basically, the conversation is that reparations, as we know it in federal court, is dead. So now we have to start talking about another type of reparations. There are only two reparations cases going to court. One is already there, is the Malcolm X family reparations case that only deals with Malcolm X. The murder of Malcolm X by the New York City police, the federal government, the CIA and other groups. Uh, that is in federal court right now. The other case is the Tulsa massacre, right, which goes to the living descendants of the Tulsa massacre first, and possibly their descendants, and we have to see how that works out. But the problem again in federal court, which you will see with your own eyes, so they won't lie, is that if your ancestors in the Tulsa case and you are a descendant, you cannot be a plaintiff for them. It doesn't work like that in federal court based on the ruling in the Farmer Pelman case. Again, I talked about, like I did earlier, having these conversations about hip hop and stuff like that and delineating ourselves. Well, the real movements require organizations, require meetings in require lawyers, the real cases, the successful cases. So we don't need social media to hijack the good work, the publications, the books. We don't need social media to hijack that, right? Because social media is not involved in that. So you're going to tell me that the people who are not involved in it has more power than the people involved in it. So I will replay the video. I will make a short of it, and I will, not a short, but I will replay it on the site so that you can hear it. So let's just do something more important. Let's read the Pelman Farmer case, and let's see what reparations, what burdens of reparations that we have. So give me a second. Let me just pull it up. Let's see where it is. Because I don't want our people to be misled and nor be distracted. Let's see if it comes up. Yeah, here it goes. Pull it up and push it over here. So we're going to read the case at large. Now, Brother Reggie is boring. That's why I'm on my little channel. Because the people on the other channel that I was saying, they don't want to hear me talk all night. That means they want entertainment. I don't entertain you. I'm not here to entertain you. I'm here to inform you. I've had some of the best teachers in the world when it comes to Black studies. If the people over there don't want me, they want me to interview people, and I have no control over what those people have to say. And the other thing is, about my Cash Apps. Well, for my time, I don't ask a lot, but for my time, I would like you to donate when you can to me, because I do good work. But I'm not here to entertain. I'm not here to tap dance. And if y'all like those conversations, go there. Research is boring. Writing is boring. Scholarship is boring. Going to committee meetings is boring. Going to court is boring, right? All of those things are boring. If you want to sit behind your desk and watch a YouTube video on religion, go over there. If you want to see case law, if you want to see actual facts, you come in. I don't care if I get 150 views. I don't care if I get 200 views. But one thing I will do for you, I promise, is I will inform you. But if you want to see goofy conversations about a God that of an ancient world, be my guest. Be my guest. So they're right. They are absolutely right. This is not for them, right? And so if I have to be scolded about content, fine. I could take that. People don't want to hear. People don't want to hear what I have to say. I could take that. I could take that. But I promise you, I'll give you some of the best content on Black culture and Black American culture and ancient culture. Okay, so this case was argued. This case was argued in 2006 at the appellate level. 2006. This is when it was decided. 2006. That's been almost 20 years. 20 years ago. Now, I met the plaintiff. Yeah, I met the plaintiff when we were doing the reparations case. Well, there was a town hall in City Hall where I was asked to speak, and I was one of the youngest people to speak at a town hall for reparations in New York City. I was a speaker. So all of these new people talking about reparations, I'm just meeting them. Okay, so in the beginning of the case, here goes the plaintiff lawyers, here goes the defendant lawyers. And what this case was generally about, I'm going to summarize it, was that the plaintiff, Deirdre Pellman Farmer Pellman, she decided to have a case against corporations that insured slavery, insured the enslaved. Now, so now you would think that she could identify her own relatives that were insured. Okay, that's what you call standing. And the court seized upon that. Then they seized on some other things that we will read about tolling, statute of limitations. They will say that this happened over 150 years ago and the courts can't deal with it. Another thing that they will deal with is the suit should have been dismissed anyway because it's a political question and that the federal courts is not the best venue to deal with this. It should be dealt with Congress, Senate, the president, and in local courts. These are the things that we have learned. Okay, so this is the introduction by the Judge Posner, who is usually pretty fair, but he did law, right? He alerted us to some things. 9 suits were filed in federal district court around the country seeking monetary relief under both federal and state law for harm stemming from the enslavement of Black people in America, not FBAs, right? The enslavement of Black people in America. A 10th suit by the Hurdle group of plaintiffs made similar claims but were filed in a state court and then removed by the defendants to a federal court. The multi-district litigation panel consolidated all the suits into district court in Chicago for pre-trial proceedings. Once there, the plaintiffs, all but the Hurdle plaintiffs, about whom more shortly, filed a consolidated complaint, and since venue in Chicago was proper in any event, not objected to by the parties other than the Hurdle group, whose objections we consider later in this opinion. The district court was unquestionably authorized, notwithstanding, right? Okay, so at this point, you can look at what they're saying is you can look at the federal court and that they had jurisdiction. We are also persuaded that a district court to which a case is transferred under the section 1407 can rule on a motion to dismiss the case, even if the plaintiffs have not agreed to let the court decide the methods. So they're saying this court had the ability to dismiss the case, right? Even if the plaintiffs had not agreed to let the court decide the merits. right? Okay, so then they're going to talk about some case law about dismissal, and then he goes, and rightly so. The duty to conduct the pretrial proceedings in a multi-district litigation entails the transferee courts ruling on a host of pretrial motions, many of which, whether or not formally depositive, can shape the litigation decisively. There is no reason to exclude from the court's authority rulings on motions to dismiss. So there were earlier motions of dismiss by the plaintiff, by the defendants, and this court is bringing those courts up, those dismissals up, right? Okay. It says, were it not for the hurdle suit, we wouldn't have to decide whether the district judge could have dismissed the transfer suits had the parties not agreed by filing a new complaint to his retaining them after completion of pretrial proceeding. But the hurdle plaintiffs did not agree, so we cannot duck the question. So the hurdle group did not agree to some activity that happened prior, so this court cannot duck the question. So otherwise, they would have just dismissed it. The suits are a series of mostly identical cases, class actions on behalf of all Americans descended from slaves with whom one or more of the defendants or their corporate predecessors may have been directly or indirectly involved. The consolidated complaint, the hurdle complaint, is similar, so no need to be discussed separately, alleges the following facts, for which do not vouch, we do not vouch, but merely summarize. The complaint having been dismissed before the truth or falsity of the allegations was determined. The defendants are companies of the successors to companies that provided services such as transportation, finance, and insurance to slave owners. At least two of the defendants were slave owners themselves. The predecessors of the defendants who were slave owners of one of the bank defendants once accepted 13,000 slaves as collateral on loans and ended up owning 1,250 of them, which the borrowers defaulted, and the predecessor of another defendant ended up owning 346 slaves. So the court is admitting that the defendants owned slaves, right? Also, the consequence of a borrower's default. Even before the 13th Amendment, slavery was illegal in the northern states, and the complaint charges that the defendants were violating the laws of those states in transactions with slave owners, which is correct. It also claims that there were occasional enslavement long after the passage of the 13th Amendment, and that some of the defendants were complicit in those too. So they slaved them when slavery was legal, they slaved them during the illegal slave trade, and they continued to slave them after the 13th Amendment, right? So the question is, how do these defendants escape that, right? How do these defendants escape that? Well, the legal basis for the federal plaintiff's federal claim is 42 U.S.C. Section 1982, which provides that all citizens of the United States shall have the same right in every state and territory as is enjoyed by white citizens thereof to inherit, purchase, lease, sell, hold, and convey real and personal property. So the defendants are rightly saying that and included that. A claim based on federal statute invokes the federal question jurisdiction of the federal court, but since most of the conduct of which the plaintiffs complain occurred prior to the passage of the 13th Amendment, and indeed prior to the Civil War, that means where slavery was legal, right? Section 1982 does not provide a sturdy basis for retention of federal jurisdiction over plaintiffs' non-federal claims. So they're saying the plaintiffs brought up a case after the 13th Amendment, right? And that bringing up that case does not fix what happened earlier. So that's what the court is saying. Okay, so let me read it again. But since most of the conduct of which the plaintiffs complain occurred prior to the passage of the 13th Amendment, and indeed prior to the Civil War, Section 1982 does not provide a sturdy basis for the retention of federal jurisdiction over the plaintiff's non-federal claims. And then they say frivolous federal law cannot successfully invoke federal jurisdiction. Just to dig into the plaintiffs, which are our people. But with one exception, all of the non-federal claims are within the federal diversity jurisdiction and so do not require a federal law handle. And then they give the exception is the Richard E. Barber Sr. suit for both he and the Brown brothers. One of the defendants in the suit are citizens of New Jersey. So because there are state claims, this case seems to continue, right? Okay, so then they say the district judge ruled that by virtue of both the political question doctrine and the requirement of standing to sue derived from the Article 3 of the Constitution, there was no federal jurisdiction over any of the suits, and that in any event, they had no merit because of the applicable statute of limitations had lapsed, and anyway, the complaint failed to state a claim. So the court is saying that that the complaint failed to state a claim, and that there's a statute of limitations. It occurred prior to a period that the court could address, right? So here the court is doing their work on Black people. Then they come up with the political question doctrine bears federal courts from adjudicating disputes that the Constitution has been interpreted to entrust to other branches of the federal government. So now the court spits at the plaintiffs and say, you shouldn't even be here. It's a political question. It's not a federal question. Okay, so let's go down and read some more. Okay. They say a case that sought reparations for the wrong of slavery would encounter similar obstacles, but plaintiffs have been careful to cast their litigation as a quest for conventional legal relief, right? So they say to plaintiffs, you are smart. You've cast your litigation for conventional legal relief, right, of what is due in the context of the laws, all right? All the defendants or all the plaintiffs are asking is that the federal judiciary is to apply state law plus one federal statute to the defendant's conduct. They face, of course, now the judge jumps in. They face, of course, formidable obstacles quite apart from the severely limited application of Section 1982. To name one of those obstacles, watch this, family. It is highly, this is the court, unlikely that antebellum laws in northern states were intended to confer financial or other benefits on the 21st century descendants of slaves. It is highly unlikely that antebellum laws in northern states were intended to confer financial or other benefits on the 21st century of descendants of slaves. So they're saying that the old laws, you can't find it in the old laws that it apply to your descendants. Killing the case. But the obstacles to the vindication of the plaintiff's legal claims have the form of at least a conventional defense to a lawsuit. If one or more of the defendants violated a state law by transporting slaves in 1850, and the plaintiffs can establish standing to sue, prove the violation despite its antiquity, establish that the law was intended to provide a remedy, either directly or by providing the basis of a common law action for conspiracy, conversion, or restitution to lawfully enslaved persons or their descendants, identify their ancestors, quantify damages incurred, and persuade the court to toll the statute of limitation, then there would be no other obstacle to the grant of relief. So the court said, give us a case, right? Give us a case that fulfills all of these, and you will have no obstacle to a grant of relief, right? So they looked at the defendants and they said, sorry. I mean, they looked at the plaintiffs and said, sorry, you can't show a law that would have established you relief, you descendants, right? You can't show us where it actually happened anyway to your ancestors. You can't quantify the damages. You have to identify their ancestor, your ancestors, right? And the harm that's done to quantify damages and occurred. And then you have to persuade the court to toll, meaning to kind of set aside the statute of limitations. If you can't do that, and it's a political question, it may be a political question, whether rather than a federal question, off you go. We are going to dismiss any case, any federal reparations case, any federal reparations case on descendants of slavery. We would, Ben knows that we would have to tear down the compromise of 1850 and 1877. What do you mean by that? Just help me with that. I think I know what you're saying, but what the court just said is that you have to identify your ancestors and the harm to them and convince the court. So you can't just be talking about ghost people. I'm like, oh, my ancestors, our people. The court does not deal with that, right? This is what the court is saying. But we think that the district court was correct, with some exceptions to be noted in ruling that the plaintiffs lack standing to sue. So they're saying, you plaintiffs who are suing us, you lack standing to sue, right? Now watch this. It would be impossible by the methods of litigation to connect the defendant's alleged misconduct with the financial and emotional harm that the plaintiffs claim to have suffered as a result of that conduct. Wow. The defendant's alleged misconduct with the financial and emotional harm that the plaintiffs claim to have suffered, meaning the people who are suing suffered, not their ancestors, right? Not their ancestors, but the people who are suing. You can't connect financial and emotional harm to you. Okay, so how many people see that as a problem, right? Okay, so for example, Edna is alleged to have written several insurance policies on slaves in the 1850s in violation of state law, right? Because slavery had ended, applicable to the company and to have obtained premiums for the insurer. The court is admitting that the slave owners that will assume exceeded the cost of insurance to Aetna, its expenses plus the payment of proceeds if the insured events came to pass. The plaintiffs argue that Aetna's net income from that insurance was a wrongful profit that the company should be ordered to restore to the plaintiffs' classes. That is an argument that we should pursue, ill-gotten gains, right? We should pursue that, right? So the court is hinting, maybe you might have. Okay, so let me see what Nook is saying. Let me see what he's saying. Let's see. Wow, I can't. Let me see if I can see it all. Okay. The compromise of 1877 was an informal agreement between Southern Democrats and allies of the Republican Rutherford Hayes to settle the result of the 1876. So, okay. So, well, you said informal. That's like 40 acres of a mule, right? It's not written into law. And what the court is the court is saying clearly is that uh, you must show, right, your ancestors, right? But the court is going to do something to really tear down reparations for us in a minute, right? So these laws that you have to show your ancestors at that period, and you have to render the injustices to your individual ancestors. The class has to do that. So that means if you have a class suit, that means those in your class need to sign affidavits showing their family members in that period. If you do not do that with any expertise, then you don't meet the class specifications. You can't talk about your ancestors that were enslaved. This is how hideous these courts are. All right. So this is where they begin to talk about this stuff. And in any event, it would have distributed any profits from the transactions to its shareholders long ago, all to one side. There is a fatal disconnect between the victims and the plaintiffs. Wow. There is a fatal disconnect between the victims, meaning those who were enslaved, our ancestors, and us that are suing on behalf of them. When a person is wronged, he can seek redress. And if he wins, his descendants may benefit, but the wrong to the ancestor is not a wrong to the descendants. Comments on that? When a person is wronged, he can seek redress. And if he wins, his descendants may benefit. But the wrong to the ancestor is not a wrong to the descendants. What's your comments on that? Because this is murderous to people over here misinforming you that in federal court that we can get reparations. They are they knowingly or ignorant, right, is suggesting and not talking about this case and not what it says. And this is the last reparations case. So do you see, press 1 if you see a problem with this. There is a fatal disconnect between the victims and the plaintiffs. When a person is wronged, he can seek redress. And if he wins, his descendants may benefit, but the wrong to the ancestor is not a wrong to the descendants. So what is my brother saying? The Promise of 1850 was made of 5 bills that attempted to resolve disputes over slavery and new territories added to the United States. What this court is saying, that a wrong to the ancestor is not a wrong to you. Any comments on that? Let's see what's going on here. Any comments on that? How many views do I have? 26, 30, 40? Let's see. Let's see. How many views? Let's see how many views. I'll check it myself. I've got to rename this 12. 12 people watching. I didn't even have 26. And this is going to be my life on YouTube. YouTubing. I'll get 12 live till people subscribe, and then later on I'll get maybe 100 views. And so I think the people who are watching it now, and I have to share it and let people know that I'm on so that they can subscribe. But what I'm just doing for you, thank you, Barn Dog. What I'm just doing for you is allowing you to know that a harm to your ancestors is not a harm to you, right? So someone is playing on the ignorance of our people in the course of talking about insurmountable obstacles that we have to endure on reparations. And for me, this is a personal penalty. If look, a person who owns a channel, they have a right to decide what content is good or not, and that's fine, and I respect that. But the penalty is for me is to do it myself, which I've not done in many years, and maybe I should have and got a bigger audience by supporting other channels. But and on this issue, I think that this is merited enough for me. Okay, Solomon TV says, I would disagree on that point, but the law is clear on what must be done. Let's put it up. Solomon TV, you are absolutely right. I would disagree. And in my next show, I will talk about what I know about federal law to overcome that, right? But I don't think going into federal court again like this without 20 to 50 million dollars of a fund to pay a group of lawyers to do the case right, I think that it would be a big failure, right? If we did not do a fund, and that's what I talked about in my video. So we could disagree, but that's what the law says. So Solomon TV, thank you so much. So now, let's see. Okay. The plaintiffs introduced another claim of injury by asserting that the defendants refused to violate their own state laws by doing business with slave owners. There would have, if they refused, the defendants refused to violate their own state laws by doing with business with slave owners, there would have been less slavery because their refusal would have been tantamount to subjecting the slave owners to a partial boycott. That would have raised their costs, and by making slavery less profitable, may have reduced the amount of it. Might, watch the court, not would. Here's your court. Might, but not would. Because higher costs might simply have depressed the price of a slave. And had there been less slavery, the argument continues, some of the ancestors of the members of the plaintiff's classes would not have been slaves, but instead free laborers, and they would have had some disposable income, part of which they might have saved rather than spent, right? But this causal chain is too long and has too many weak links for a court to be able to find the defendants' conduct harmed by the plaintiffs, right? Let me just see. Message. I'm online. Wait your own. Let's just see. I'm online. Okay, I'm online. Sorry about this. I am online. Okay. Thank you. Okay, so it is impossible to determine how much, if any, less slavery there would have been had the defendants not done business with slave owners, which would affect a diminution of slavery would have had on bequest the ancestors of the class members, and how much. So now the court is really beating up this reparations case, right? They're looking at every little knob that they can turn, right, for the floor to fall. Now, they say, they give an example. I don't want to read the example. I think that you get the point. Let's go on. Okay, even if compliance with those local laws would have curtailed slavery, and even if it could be shown, which it could not be, right? The court is horrible. that as a result of the hypothetical curtailment of a plaintiff's remote ancestor would not have been a slave, but instead a free laborer, how could the wages that the ancestor would have earned as a free laborer to be shown to be influenced the wealth of the remote descendant? So whatever your ancestor made, right? Uh, how could it be connected to you, right? Um, let's see what else. Okay, I just checked the chat. All right. So, okay. So let me just see what I want to do. Uh, okay. Nor are the problems of measuring and tracing alleviated by recasting the relief sought as the restitution rather than the damages. Restitution, the transfer of the wrongdoer's gain to the victim, is an alternative to damages, the monetization of the victim's loss. Okay. Um, it is a sensible remedy for egregious misconduct, but because it makes the conduct worthless to the defendant by taking away his profit, even if he exceeds the loss to the plaintiff, but it is presumably an injury. So they're saying, well, yeah, it is still an injury. It is a remedy for legal wrong. And there's no way in which to determine what, if any, injury the defendants inflicted on the members of the plaintiff class. So that's where, at the last sentence, that's where they kick us in the back. There's no way to determine what, if any, injury the defendants inflicted, right, on the members of the plaintiff's class, not their ancestors, you, the plaintiffs, you. And again, if there was a legal wrong, it would not be a wrong to any living person unless there was now here's the killer. And again, if there were a legal wrong, it would not be a wrong to any living persons unless they were somehow the authorized representative to bring suits on behalf of their enslaved ancestors. Let me see, Benjamin Sut. I appreciate my small audience. Explain the difference between slavery and free labor. Um, I don't think anyone would give free labor, right? I think that slavery is forced labor, right? And thus the person who is inheriting the labor, right, gets the free labor. The person who's enslaved is in fact being separated from his time and being forced to do it, right? So who would do free labor and have to feed off their family? There is a difference. But in what I am reading, did y'all read that? Press one if y'all read that. Press one if you read and understand that, right? Press one. Let me go and read this again so that you can read, so that you can see it. Benon says there is none. Free labor is if it's voluntary, like I want to volunteer, that's free labor. If I'm forced to do it, then that's enslavement, sharecropping, things like that, forced to be tied to the land. But let's deal with this. And again, if there were a legal wrong, it would not be a wrong to any living person unless they were somehow the authorized representatives to bring suit on behalf of their enslaved ancestors. What do y'all think about that? Comments? Does that destroy reparations in federal court? Press one. I got 12 people on here, maybe 11. What people are doing with you on social media, right, is what they're doing with you is that they are using words like reparations to get into your emotions, but they haven't read the case. And if they read the case, they would know that if there was a legal wrong, it would not be a wrong to any living person unless they were somehow the authorized representative to bring suits on behalf of their enslaved ancestors. Thank y'all so much. Now he says, with some exceptions to be noted, the plaintiffs are suing redress harms to third parties. So our ancestors are third parties without being authorized to sue on behalf of those parties. So my great great grandfather, my great 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 grandmother did not authorize me. My family did not authorize me. My family will fight against me. Some of our families, because they don't think maybe I should be the plaintiff. Maybe they should be plaintiff. They want to know how much money they're going to get if we win, right? We're going to have infighting on authorization, right? Right? Like we do with family lines when there are states and we have uncles that get the land and they get a deal from a realtor and they sell the land on behalf of the family and don't give the rest of the family anything. That has happened over and over again. An aunt, an uncle, right, that was closest to our grandparents, somehow they're able to get on the deed of the land and they sell it for their own selves. That has happened to my family and me and my family so many times, right? So, but in this case, the last reparations case, with some exceptions to be noted, the plaintiffs are suing redress harms to third parties, their ancestors, without being authorized to sue on behalf of those parties. It is like a suit by a descendant of a Union soldier killed in battle against a Civil War era gun manufacturer still in business that sold guns to the Confederacy in violation of federal law. A federal court could not entertain the suit because the plaintiff will be unable to prove a harm to an interest of his, such as a bank account that the law protects. The law is not going to protect your bank account, right? You can't sue on behalf of your family member that was a Union soldier, that was killed by a gun manufacturer that sold to the Confederate Army. This is how they playing with us. It is possible that had the ancestor not died when he did, he would have become a wealthy person and left bequests so immense that his remote descendant, the plaintiff, would have inherited more money from his parents or grandparents than he actually did. But this is too speculative an inquiry to provide a basis for a federal suit. Game over. Game over, right? So then the two cases just cited and others treat remoteness as a limitation on Article 3 standing. Still, other cases treat it as a non-jurisdictional limitation on who may sue in federal court, but still a limitation. A family, the burdens of a federal lawsuit against slavery is immense. Anybody using reparations in federal court right now after this case is purposely doing it, right, to get to your emotions. Reparations in federal court is formally dead. I've written an article, Reparations is Dead, How to Resurrect It, in print with Dr. Jahi Issa. I have known this for many, many years. And I laugh at these people talking about reparations. Now, when I will give it to ADOS because they was talking legislatively, right? She was trying to talk to Warren and some other people. So she wanted, Yvette and Tone wanted they wanted legislation, right? The other groups of people, it's still open as to and confusing what are they talking about. Tone is a lawyer. Tone read this case, so Tone knows. So he said he understood the political question burden, right? And so he went legislatively, right? But here's the funny part. If you're doing social media signal boosting, you would do something to get to the legislators. So you would identify the legislators, right, uh, that needed to be talked to, and you identify to them what needs to be talked about. But just using the plight of our ancestors to emotionally charge people and get into this infighting on whether or not these Tezers or whatever you want to call them deserve reparations is a nothing burger. Is a nothing burger, right? So the court continues. The court continues, but okay. In a hypothetical case of the Union soldier, the litigant with the paramount interest in the case would be his estate, and the damages the estate could recover would include whatever amount of money he would have wanted his descendants to inherit. If the descendant could sue the tortfeasor directly for that amount or for the tortfeasor's profit in a suit for restitution, there would be either double recovery or an impossible task of allocating the monetary recovery between the descendants and the estate. Okay. So then a few of the plaintiff's claims, however, as we noted at the outset, are claims of subjection to involuntary servitude after it was outlawed by the 13th Amendment and indeed in the 20th century. Now, so that the plaintiffs put this in the case as a test, right? Cain Wall Sr. claims that during the time that he was enslaved, which he contends extended into the 1960s. So one of the plaintiffs is smart, Cain Wall. He said that he still was enslaved, and he contends it up until the 1960s, right? So now that's real great. He contended that he is still enslaved. One or more of the defendants were doing business in Mississippi or Louisiana, right? Some of the defendants had to reason to know of the enslavement of Cain Wall and yet failed to take steps to eliminate the same, while they continued to inure benefits from the illegal but sanctioned system of servitude post emancipation. But there is no claim that the defendants subjected Wall or any other class member to involuntary servitude or did anything to perpetuate or exacerbate his condition. The claim is that they took no steps to free him. The briefs suggest no basis for thinking that there's any kind of good Samaritan legal duty to eliminate a violation of the 13th Amendment committed by someone else. See, the law is very interesting. Okay. These judges will poke holes into even reasonable conversations without hundreds of affidavits and briefs, right? They will seize. Remember, you have a right to an attorney, right? Anything you say or can be held against you in a court of law. Well, in this particular case, what he said in his brief, they poked holes to it, right? Okay, the limitation that Article 3 places on the right to sue in federal court requires us to affirm through striking with prejudice on the basis of lack of standing. Black people, you cannot sue for your ancestors unless you have control over their estates. And even when you do that, right, then there's statute of limitations. And even when you do that, right, you have to identify exactly how that ancestor was wronged. And this is what the court is saying. First, although most of the plaintiffs and class members are suing as their descendants rather than as representatives of their ancestors' estates authorized to sue on of those ancestors' behalf, a few do claim to be suing in such a representative capacity. It is highly unlikely that the estate of anyone who died a century or more ago, or indeed more than a half a century ago, for although many former slaves survived into the 21st century, very few would still have been alive 50 years ago, which is to say 1956, 91 years after the end of the Civil War, has not yet been closed. But the district court judge accepted the purported representatives. Now you're the damn purported representatives, right? But the district court judge did accept you, right? To embarrass you later, right? But the district court accepted that the purported representatives had a right to sue on behalf of their ancestors, and the defendants offer only a perfunctory rebuttal, right? So the defendants didn't even rebuttal that. They say, you know what, we'll do it later, right? Because we will find judges that will help us. So we don't have to fight it all now. We'll spend some money, and they were corporations and they had the money to spend. But we shall assume without deciding that some of the plaintiffs are legal representations of their slave ancestors, right? So we shall assume without deciding yet that some of the plaintiffs are legal representatives of their slave ancestors. These plaintiffs do not only escape the objection to standing that the suit seeks damages for injuries actually suffered by third-party ancestors, no longer third-party ancestors, but the real parties in the interest, merely represented by the plaintiffs, but have less to prove. They just have to prove the injury to their ancestors. The trickle-down question is eluded. So the court now is basically saying, let me play with you. I'm gonna play with you. I know that you don't have any standing in court, and I'm gonna get that later, right? I'm gonna get to that later, right? Now prove the direct injury to your ancestors. Now this is where we completely fall apart. Yeah, but we were just enslaved. It was forced labor, right? And it was ill-gotten gains, and we didn't get anything, and we lost our property, yeah, right? And the court is saying, okay, fine. Now you show the particulars. Show the particulars. Don't talk about all of our people. If your grandparent is Jenny Mabry, right? If the great grandparent that you're talking about is Jenny Mabry, right? I'm gonna play with you. I'm gonna let you be the fake legal representative for a while. But now tell me how Jenny Mabry, who is my actual grandfather's on my father's side mother, Jenny Mabry, who was not married to so my grandfather was born out of wedlock, and the her her companion, right? Pender, right? That was his name, right? Um, the court wants me to show particularly how Jenny Mabry, who was a sharecropper, who I know that she died on a sharecropping on a farm during the swine flu period, but the court would say that, and she died of exhaustion. She died of exhaustion, Jenny Mabry, my great great grandmother. Uh, but the court will say, well, Mabry, she died of swine flu. She died of exhaustion on a plantation that she was sharecropping on, and but her cause of death was through swine flu. So, Mr. Mabry, why are you in our court? Well, she was sharecropping. Okay, she was sharecropping. That's fine. You have to list the defendants, the plantation owners of Jenny Mabry, to proceed, right? You will have to. Well, all I have is a death certificate that says that she died. But Mr. Mabry, you're not producing the particulars. You have to tell me how long they worked. Uh, my great grandmother was a migratory sharecropper. She worked on different farms, right? The truck would come, and the truck would pick you up, and the truck would take you to farms, and you be in a farm for a season. That's just how sharecropping worked in the parts of North Carolina where I'm from. So I don't know how many seasons she worked for that sharecropper because I only have a death certificate. So well, they'll say, well, Mr. Mabry, the if you find that sharecropper, well, you're gonna have to show me how long she worked for that sharecropper, right? And you're gonna have to show me some payment. It's insurmountable burden that I would have to pursue uh, for for my great great grandmother Jenny Mabry to get anything. Okay, so the court now slams this case. In all likelihood, it would be impossible for them to provide injury. That's what I'm talking about, requiring us so that would connect the particular slavery transactions in which defendants were involved to harm the particular slaves. But in any event, suits complaining about injuries that occurred more than a century and a half ago have been barred for a long time by the applicable state statutes of limitation. It is true that tolling doctrines can extend the time to sue well beyond the period of limitations, but not to a century and more beyond. Slaves could not sue, and even after the 13th Amendment became ineffective, became effective in 1865, suits such as these, if brought in the South, would have not received a fair hearing. So the court says, the court is laughing at us. Well, the slaves couldn't sue, and even after slavery, they still couldn't sue because of the climate of the black codes and Reconstruction, right? They're laughing at us. However, some northern courts could have been receptive to such suits, and such the defendants are and were northern companies. Then you would have been proper in those states. Even in the South, descendants of slaves have had decades of effective access to the courts to seek redress for the wrongs of which they complain, and if not, as if it had been a deep mystery that corporations were involved in the operation of slave system. The second qualification concerns a claim rather buried in the complaint, but not forfeited, that in violation of state fraud or consumer protection laws, uh, give me 1 second. Hey, Mark. Yeah, I'm finishing up. I'm finishing up this live that I'm doing on Africa Online TV. Okay, so that's where I am right now, Africa Online TV, finishing up. I got one more page to read, but you can check it out, Africa Online TV. Thanks. So the last part of this case is consumer protection laws, right? So I don't have to go any further. Um, I don't really have to go any further. I think that you all get the point. My point is to the community. My point is to the community, and I'll stop sharing, and I will put the the invite in. So let me stop sharing. And I'm going to put the invite in. So let's see, invite guest. This here. Okay, great. And here is the, uh, okay. So let me read the chat for a second. Okay, great. So there's the invite. So if someone comes on, uh, please help your brother Reggie out, because brother Reggie wants to know why these groups are running around talking about reparations, but not detailing the burdens of reparations or describing it, right? Brother Reggie is kind of thinking that these groups of people are fooling us, fooling the populace, right? Brother Reggie is um, not just believes that. Reggie knows that these people are not using the language of reparations, of real reparations, right? And so when these people start to say that we need to delineate ourselves, um, it's time for us to, get our own flag, and, the red, black, and green flag is not working, and we need to create this new group. I'm trying to give you some information to kind of help you understand the difference between real reparations and people organizing on something with insurmountable burdens. So, Mr. Morpheus is correct. Uh, reparations is dead. And people are getting into people's emotion. And how I know this is because when I listen to the language of these people, they don't have any solutions. What they have is, we're going to attack this group because they're trying to take something from us. So, Mr. Morpheus, who's on, Mr. Morpheus was in the period of hip hop. Mr. Morpheus is on a flyer. He's Shonsky. He's on a flyer with many of the pioneers, right? Um, he was actually there. He ends up arguing with people who names were not on a flyer. And all they're arguing for is things like reparations, not reparations, but hip hop is a foundational black, uh, uh, and that's supposed to be more important than what was happening in the Bronx, right? More important than the truce that happened between black gangs and Puerto Rican gangs, right? Um, that what they're talking about is not giving an iota of res, I'm not going to say respect, but any financial gain to the families, right, of the descendants of the hip hop pioneers. And Morpheus is a hip hop pioneer, right? So all of this becomes BS talking points. It becomes BS talking points. That's all it is. Invite guests one more time. Yeah. To push a social agenda conversation. That's all it is. And you people are watching the internet, seeing the infighting. Who cares what Fat Joe says? Joey from the Bronx, Joey from Forest Projects, right? Who cares? Is what Joey says, right? When we know, how can I say it's partially true, right? It's at least Joey is from the Bronx. He's from the area. But Joey's younger. Um, when Joey's talking, he's talking how Bronx people talk. Now you uppity people can go and examine and what he says, but he's talking specifically to, he said FBA. He didn't say Black Americans, but FBA's own Black America now, right? They own Black America. So if you talk about Black America, you're talking about FBAs. But uh, but there's a lot of complications when you're talking to somebody, right? Uh, who at least is from the area, contributed in his own way to rap, not really hip hop, but to rap, and you're seizing on a talking point of an individual. We all have freedom of speech. So you're going to use Fat Joe to attack all Puerto Ricans? You can't do that because all Puerto Ricans don't feel the same way as Joe says. All Puerto Ricans don't talk the way. Now you want to talk about what people's grandmothers and people's grandfathers and fathers, they didn't want you to deal with Black people. Well, I mean, how? That's hard for me because I mean, I grew up with a Spanish family. They adopted me, right? Even though I had real parents, they adopted me. I mean, I went to Puerto Rico in like 79. I went to their family homes, right? I was a good friend of their sons, right? I was their brother. I was in the house all the time. They took me to Puerto Rico. How am I going to say something? I can't. I'm from the Bronx. I can't say nothing about those people. Those people are beautiful people. And I was around during the time period of hip hop, right? I went to the programs. So I know who was there and who wasn't there. And I know a lot of people who spoke Spanish who were dark skinned wouldn't speak Spanish because they just wouldn't speak Spanish. There was no need to speak Spanish when people couldn't communicate, but they were Afro Puerto Ricans. And when I went to Puerto Rico, I saw I saw I saw Africa. When I later went to Africa, I saw the same groups of people in Africa in the same situation, right? I went to rural Puerto Rico. I went to Salina and Cachete. I went to their family homes in the bushes, right? People walked around barefoot, right? Um, People farmed. People had cows and pigs and roosters for subsistence, right? Um, and many of these people, there was a diverse group of color, but because they were in the sun, most of them were brown. Now, I'm a tezer because I'm telling the truth, right? I'm telling the truth. I know that the Bronx was largely Black American, right? But they were not necessarily foundational Black America. And the issue with the enslavement is a problematic in New York because slavery was abolished before the Civil War in the North, in New York. But I can't tell the truth. I can't tell the truth about history. I have to be overrun on some of these other channels, uh, and I hear so much falseness, and the people could look it up, but they won't look it up. So, unless there's some more comments, I have such a small audience, but I do know why, because I have to start from scratch. So I'm depending on you to like the video, to share the video. I'm depending on you, um, if you want to hear the truth. So what I did was gave you an introductory video. What I did for you is I read the case so that anybody who listens to my video knows that reparations, federal reparations, is dead. And anybody using that is suckering you. And anybody else who uses that uh, uh, means that they're either ignorant or it's purposeful. Okay, so now let's see what's going on with this hip hop. Okay, Minty Hotel. Peace. Great topic. It's definitely got my attention and wheels turning. Thank you. But I feel hip hop should be left out of the conversation respectfully, and I do not disagree. I'm concerned that it's being brought up in the conversation. And that's why I say it's a nothing burger. So, Minty Hotel, I agree with you more than you know, right? It's a nothing burger. Just like having a show and calling up some person from the Caribbean or somebody who's in Africa who is not in America and talking to them. They're not in America. So why talk to them, right? Or talking to a recent immigrant to America. That's a nothing burger. You're not talking to an organization. You are missing, not you, uh, the people are missing the forest for the trees. Who is the oppressor? The oppressor is the people who wrote law, people who oppressive law, people who oppressed us, right? White supremacy. I thought that was the enemy. Now the enemy is people that got freedom of speech like you. That's the enemy. See, that's why uh, uh, college is sometimes important, right? Sometimes important. What's more important is you do your own research. You read. Reading is probably more important. But we don't have people who read. We have people who rely on social media and charismatic people. We have a lot of homo association, men joining men because they're charismatic. That's homo association. I didn't know the term, but a woman told me about a woman scholar, a PhD, and said to me personally, hey, Reggie, you might be, and you should check because you're probably engaging in homo association. It's not sexual. It's just that you're following men without checking their sources. And if these men were so great, right, there'll be better treatment of women, better treatment of their households, right? Um, but most men follow men that they want to look like, that they want to be like, right? Because they feel that they're inadequate. And she's a PhD. Can't tell you who her name is, but she broke me all the way down. But she said, "But Brother Reggie, I like you. You're good. You're a good researcher. Just check what they say, right? Because for her, it's problematic when her peers, PhD men, black men, right, or sleeping with their students, meaning sleeping with the daughters of other black family members who simply go to college for a grade, right? Uh, to pursue a degree, to getting out the world to work, and black people who's supposed to be loving black people are sleeping with other black men's daughters for grades. Right? And she says a lot of these people, Brother Reggie, cover this up because they seem to be doing something for black people. But they seem to be talking black and writing black and doing all this black stuff, but they're really exploiting other black people's daughters. And I said, oh, wow. And then it hit me. I could say people are people, but then I could say that those people who talk about black people who are influencers of black people, they need to put themselves in a higher moral category and do thus. So the real problems, family, before I close, because I don't have much of an audience, is one, Paramount is organizing for our best interest. Two is education about the subject that you're organizing for, right? Organization, education, which requires your personal research. You keep following these charismatic people, and our people will have less of a chance because I just showed you what we're up against. In another show, I'll talk about reparations and I'll talk about local reparations and things that are working. And I'll talk because I'm actually a writer, because I'm actually engaged in a topic. I've actually spoken at city hall meetings, spoken to elected officials, went to the programs, but I'm nobody because y'all have homo association. Y'all want to follow people that may have better diction. That's their best quality. Maybe are more charismatic. Maybe even like the way they look. Some of you don't like my nose on the other show. People don't like my big nose, my big African nose. Don't like my nose. Talk about the stupidest things instead of my work in Black studies. Right? You sisters, please stop following these people, right? Unless you do some research. They're not going to be good men for you, right? They're really not the men that you want, right? You might be better off with a street person. At least you could talk street to them. But to be caught up in somebody's charisma or they saving Black people, uh, check that. Just don't be their honey in the bed, right? For their pleasure. Don't do that, right? Especially these young charismatic people that's on YouTube. Giving yourselves up for what? Because you want to be associated with them. I see a lot of that. I don't mind. I mean, I have no listen. We're sexual people. Those things happen. I got that. I got that. I but sisters, if you do it because don't do it. Don't do it for don't leave the culture out of it. Just say you want to sleep with that person. Don't mix what they're doing with your personal needs. Don't do that. Just say you like the way the person moves, you like their whatever the case, and you do it for that purpose. Don't be following these people and giving them free labor and they don't give you anything. And I'm gonna tell you, there's a lot of free labor stuff that's going out. Morpheus, he had to sit me down. He had to told me about exposure exploitation. Exposure exploitation is when you pay to be exposed, right? But then there's another part of it when you are being exploited for exposure. And you get into a loop where you're not getting your fair share, right? So, and that means you want to be on everybody's show and you want to talk, but you're doing it for free. For exposure, right? And so that's a problem. But getting back to this point, Black people, our people, reparations is dead. Anybody who's using that, who's not part of a local reparations movement, is hustling you. I just showed you on the screen. It's a hustle based on your ignorance. Y'all want to do something for Black people. They owe us. They sold us, right? They sold us, so they owe us. The courts say, nah, we don't owe you nothing. We owe, we might have owed your ancestors, but not you. But the Native Americans, uh, they have a different issue in America. They are domestic dependent sovereigns. They can run their own governments, right? They can create their own laws, right? Their own property laws, right? Their laws, their property can be passed down to their descendants. Not in America, not in the United States, except for an exception. Your brother wrote the Black City Plan. That's me. City law, county law can fix that, right? But you want to listen to the dudes with the fresh haircuts, right? Make you feel good, say some things, but they're not saying anything to the oppressor. When have any of these people ever had any conversations or disagreements with the oppressor? When? Show me. Let's be honest. They argue with Fat Joe all day. If they go to the record companies, they want a deal. Then there's like the Jesse Jackson formula. We're going to make noise to these corporations, single you out, tobacco companies, until the tobacco companies and these other companies pay Jesse, and Jesse going to go quiet. See that strategy right there? See, we've been hustled. So how do we fix it? Keep following me and we'll talk about it. So let me just check the chat. Anybody got any last minute comments or anything like that that I should know about? Anybody? I'm sorry the audience is so small. I'm sorry that you don't have a lot of people to, but that's the payment. That's what it is. I if people on these other channels say that I'm boring and they don't want my content, I'm 59. I'm gonna be 60 years old in about 2 or 3 months, right? I'm gonna pay more attention to my investments and stuff like that that I have, right? I'll be looking forward to Social Security, the old man check, right? Pretty soon. I love you, Black people. I really do. Anybody that knows me knows that I love Black people. I just question why you give your money and your resources and your time, right, to people that are hustling you. So here's my Cash App. It's on the screen, but I'm gonna type it. Um, Buy me lunch. I appreciate it, right? It doesn't cost you that much, but it does for some of you. Does cost $1 too much, $5 too much, and I just want to give you something so that you can check what these other people are saying when they are diverting your attention for clicks and giggles. So I have part 2 to this where we talk about strategies. And we don't have to do any infighting or any racial or phenotypical or location delineation to get stuff done, right? So join me. And it's the bad thing about this thing is that it takes me sometimes a week to do a show. Why? Because I want to give you my best thoughts, right? Sometimes now I have to put graphics on it and stuff like that and do a video, right? It costs me, but it's always costed me, right? To give you some of the best information that I can on African culture, ancient African culture like Kemet, and certainly on Black America against my many opponents. So with that said, I think that I am going to end the show. Um, I do. So with that said, I want to say thank you, and let's just continue talking, and let's get the facts straight. and stop the homo association and all this other stuff that's going on, and try to understand that reparations is dead, and how we can resurrect it, and what else can we do. So with that said, I don't have anybody chatting, so I want to say, Morpheus, thanks for coming on. Bond Dog, thanks for coming on. There's so many of you. There's a few of you that come on. Mika, thank you for coming on. Ben Osut, thank you so much for coming on. Minty Hotel, thanks for coming on. I love my fro. My sister love my fro. Happy New Year. Thank you for coming on. Please share, like. Solomon TV, thank you so much for coming on. Who did I miss? I didn't have a lot of people on the chat, so I just want to check. Brother La, my good brother La, peace to you. Peace to you, La. I see you on the block. Born Eternal Lord Allah, peace to you. Thank you. Who else came on? OG's videos, peace to you. Let's see who else came on. And that's about Christoph Heretic. Peace to you. So, but Born Dog, thank you so much for directing the people to chat. And let's help build a educational channel, right? Rather than an informative back forth channel talking about religions and things like that people can't prove, right? And please, I encourage you to support. If you want to support hip hop, find out who the pioneers of the hip hop is, and help people create a fund for them, because they have children, instead of this back and forth with just to have it, just to have these back and forth conversations. Just be a little bit focused on who's telling you the message and what ultimately is the message going to do. Please know the difference between something that's real and a nothing burger, right? A nothing burger. What some Caribbean person says, their grandmother says to them, and they say, well, my grandmother said that y'all dirty. That's a nothing burger. Tell me that you're doing work against an organization, right, of white supremacists, right? Tell me that you're doing that. Tell me the action. Don't tell me that you're responding to some damn comments, right? That means you're a groupie. You ain't got to come back to my channel. You're a groupie. That means you like men. You like looking at men who are charismatic, and you're a groupie. And then with that groupiness, you want to inform and direct other people, right? That's going to be your new fan thing, like you into sports. I want to know your education, your school. I want to know what books you read. I want to know who your mentors are. The worst thing is I hate these speakers out here who got no mentors, who love our people. I just can't. I can't take that. Absolutely. I mean, it just bothers me when some of these people present themselves and they have no known mentors. That means they did it all themselves, and people follow them like everything that they say is well researched and just and right. Black people, stop being groupies. Follow the people that actually do real work. Not that they said they did work, but how we know real work is an organization. What organization are they in? And did they found it, or did a mentor find it? Right? Stop being groupies. Sisters, dress down these dudes. Like, you might turn on a video and spend a few seconds on them. Don't fall in love with these dudes. You're just going to be there. You're just going to be in their bed. And I'm not breaking people's game, because we're at a time period where we need unity. We need to show the moral side. We got to stop this blacks killing blacks. Other day outside, it was so funny. I was in McDonald's, and the girls were playing. These young girls was playing, playing with the boys like they do. And this girl, she put her phone on the table, and she went out there to, show how strong she is and fight. And I saw another dude, he like 16 years old. He took her phone. So she comes back and she's looking for a phone and she's stressed out. So I walk outside McDonald's because they were outside, and I said, sis, if you want to know where your phone is, he got your phone. So ultimately, he had to give up the phone, but he ended up dropping the phone. He didn't want to give it to us straight out, right? So now I'm leaving McDonald's, and they outside. Here's about 4 or 5 of them, and they talking about me. They say, yeah, this old nigga. That's what they call me. Little 16-year-olds. Slow nigga. He ain't minding his business. So I'm hearing that. So I turn around and I said, the fact of the matter is, you were stealing another black person's phone, and it was a female, and that was sucker move, right? And so she is my business. And they was like, shut up, you old nigga, this, that, the third. Yeah, right, and all of that stuff, right? And I'm like, okay, cool. And then one of them was like, yo, mind your business, old nigga. She's 16 years old. And I said, what you gonna do about it? And he pulled out a knife, a paper cutter. I said, okay, this is getting interesting. So what's running in my mind is, one is my own safety, but two is that since he pulled out this knife, should I murder him? But he's 16 years old. He doesn't know what I'm going to do to him. And I looked at him, and I thought about his parents, and I thought about my own safety. And then the security came out, and they grabbed him, and they said, what's in your hand? And he's over here. No, I'm going to murder him. I'm going to kill him. I'm going to murder him. And I'm at this point, let him go. Please. Let him go. Because now I'm like, you're not my people. I don't care about your mother, your father anymore. Let the boy go. Because it's not going to take me long to do what I'm going to do to you. Right? And at the same time, another part of me, it's like you got two things going on. One is that he deserves it. And maybe down the road, he's going to get what he gets. Right? But the other part of me said, you know what, Reg? Don't do it. Just walk away. Be that person that you are every day. You love black people. Unless he runs up on you and with his little crew, right? Then you have to do what you got to do, but walk away. I say that to say to all of you is that knowledge, the love for your people, but you also have to think about your best interest. You have to balance that. Knowledge helps you balance that. But I know I know some people in this chat personally. They would have almost done exactly what I've done, but these people are very super capable, right? More capable than me, and I'm capable, right? I'm just saying these are real things that's going on in our lives. But now with this Fat Joe situation and this back and forth, listen, I'm gonna tell you that this could turn out in a way that people don't really want to turn out to, because there's agitators. We got to take the high moral road. We got to make our point. It's not that serious. Make the point. And Joey from the Bronx is not completely wrong, right? He's not right the way he said it, but why expect him to be the best articulated when he's just a Bronx rapper with no college? Why do you want more? Why do you want more from him? But at the same time, you listen to all these rap records, right? You listen to Big, You listen to Tupac, right? Do everything that they say is right? Nah. And it led to something. Unfortunately, these things led to their deaths. Rap and hip hop is a form of expression we shouldn't really take too serious. Running around talking about whether or not these people were, it don't got nothing to do with you. You ain't from the Bronx. Got nothing to do with you. And I know that you're playing the people because you're not doing anything. When somebody, when Morpheus bought CC, Les, right, and Laura Abba bought Riri and FaZe, did y'all support them? Nah, you just want entertainment. When you just want entertainment. Black people, we got to do better. We got to organize, get educated, right, and do better. So look out for part 2 of this show. You can hate me or you can love me, but one thing I'm gonna do is I'm gonna give you facts. Go keep watching those other shows and not supporting me. That's you. That's where you are, not the people who are watching now. I'm just saying the wider group of people, the people who are on watching me now. I love them. I love each and every one of you. But I want y'all to be carriers of a informative condition, a positive condition, rather than a virus of entertainment. So it's 9:33. I want to thank everybody much. Spread the video and peace and Black power, real Black power, not somebody trying to take over Black power. Next thing I know, it won't be uh, Black power, it'll be foundational Black power or ADOS power, right? We got to fix this. Peace.